My name is Michelle Uzetta. I am senior counsel at the Disability Rights Education and Defense Fund. DREDF is a national law and policy center focused on disability rights issues and disability justice. We're also a support center for qualified legal services providers in California. A couple of housekeeping type things. The MCLE for this hour of presentation is still pending. The state bar is backed up in approvals. So as soon as for those of you seeking MCLE, as soon as we have that figured out, we will send you the forms and let you know. I also want to let people know that I'm off screen, as will be my co-presenter, to allow the ASL interpreter to be highlighted for people who need that type of accommodation. And then I would ask that during the presentation, people should feel free to introduce themselves in the chat. I think we have over 200 people registered for today. I don't know how many will show up because it is Friday, but use the chat for that purpose or to share any information or links that you think are of general interest to the group on this topic. I'd ask that you restrict the Q&A option for asking questions that we may be able to get to, time permitting, at the end of the hour. So again, general stuff in chat. If there's a question that you'd like for me or Amalia to answer at the end of our presentations, time permitting, put those in the Q&A. And with that said, I'll get started. So I'm charged with doing a presentation on the right to assistance animals in housing. This first slide cites both the Fair Housing Act and the Fair Employment and Housing Act in California. Under both of those laws, reasonable accommodations must be made for people with disabilities if they need those things to have equal opportunity to use and enjoy their dwelling. And one common request that housing providers are obligated to fulfill is for a person to reside with an assistance animal. So if there's a no pet or no animal policy at a particular housing complex or unit, that should be waived as a reasonable accommodation for someone who needs an assistance animal to use or enjoy their housing. And the citations are on the slide. And I also want to note that these slides, I will send them out after the presentation to everybody who registered. So what is an assistance animal? Under the Federal Fair Housing Act, an assistance animal is an animal that works, provides assistance, or performs tasks for the benefit of a person with a disability, and that's a service animal, or that provides emotional support that alleviates one or more identified effects of a person's disability. And these are commonly referred to as support animals or comfort animals or emotional support animals. Collectively, the federal law refers to these types of animals as assistance animals. Under the Fair Employment and Housing Act, California's law, the term assistance animal is defined as an animal that works, provides assistance, or performs tasks for the benefit of an individual with a disability, or provides emotional, cognitive, or similar support that alleviates one or more identified symptoms or effects of an individual disability. So both of those terms are consistently defined. It's important to note that assistance animals are not pets. There is no special training required for an animal to be an assistance animal. However, there has to be a nexus or connection between the individual's disability and the assistance the animal provides. There's no legal requirement that an animal be registered or certified, and businesses that claim to register or certify assistance animals, and there's a lot of them online that are charging for certificates or cards. They're charging you for a service that's unnecessary to establish the necessity of a reasonable accommodation, and those types of things really have no legal weight. I should mention that work and tasks that a service animal provides may include things like assistance with transfers, wheelchair pulling, assisting someone with their balance or with picking up items, providing grounding when someone's experiencing a dissociative episode, providing medication reminders through nudging, things like that, alerting to a doorbell. People with a variety of disabilities can utilize service animals. Sometimes it's hard for housing providers to understand that there is such a thing as a psychiatric service animal. They assume that anyone with a mental health disability is simply using an emotional support dog, and that's not the case. If the dog actually performs work or tasks, it is a service animal. And that's important to note, just because service animals and emotional support animals have different rights when it comes to being outside of the home under laws like the ADA and things like that. So what kind of questions can a housing provider ask if a tenant or prospective tenant wants to utilize an assistance animal in their housing? There's only two permissible questions, and those are you an individual with a disability? And what is the disability related task your animal has been trained to perform? A housing provider cannot ask an individual to demonstrate the task, and a housing provider cannot request medical records or things like that. They have to accept reliable disability related information that can be provided by the person themselves, by a parent or family member, a social worker, or something of that nature, as well as a doctor. And it wouldn't be necessary if the disability is obvious and the need for accommodation is obvious. Oh, I should also note, housing providers will often ask for proof that a dog is a service animal or an emotional support animal. They'll ask for certifications and things like that that are not required. Service animals are able to be self-trained. They don't have to undergo professional training or certification. Professional training can often be very, very expensive. If an individual is able to train their assistance animal to pick up items for them or to be close to them to provide balance, things like that, that is perfectly okay. Emotional support animals don't really require any training at all, because providing comfort and love is kind of what animals do. It's their natural ability. When processing a request for accommodation involving a service animal, you follow the same general process that you would for any type of accommodation request under the law. And that is you want to be able to establish that you have a disability, that the need for the assistance animal is there, that it's reasonable to have the assistance animal there, and that there's some kind of a connection between your assistance animal and your ability to use and enjoy your housing. Animal vests, identification cards, and certificates are not in and of themselves documentation of either a disability or the need for a reasonable accommodation. Housing providers cannot require tenants to pay fees that are applicable to pets, cannot ask for additional rent or any other kind of fee, including additional security deposits or liability insurance for someone having an assistance dog with them in their housing. They cannot charge a surcharge of any kind. A housing provider is allowed to charge a tenant for damage that an assistance animal causes, so long as it's above ordinary wear and tear, and assuming that it's the provider's usual practice to charge people for those types of fees. Again, because assistance animals are not pets, any pet rules that apply at a property do not apply to service animals or support animals. So for example, if a property allows people to have pets, but says pets are not allowed in the clubhouse or in the pool area or in the laundry room, that type of restriction would not apply to your assistance animal. Also, housing providers may not limit the breed or size of a dog or any animal used as a service animal. that's not allowable. So general fears about, for example, pit bulls. Pit bulls are not prohibited from being assistance animals, even though some may perceive them to be a dangerous breed, or there may be insurance complications at a particular property with having such a dog on the property. And those do provide some challenging issues. Any kind of limitation or exclusion would have to be based on actual risks of harm. And we'll get to that concept a little bit later in the presentation. And that's what the bottom of this slide says. Housing providers can limit access based on specific issues with the animal's conduct because it poses a direct threat or fundamental alteration. Under California law, housing providers are permitted to have lease terms or addendums that reasonably regulate the presence of guide dogs, signal dogs, or service dogs. Arguably, this state law provision is preempted by the Fair Housing Act, because the Fair Housing Act prohibits reasonable accommodations from being conditioned on execution of additional documents or agreements to additional terms and conditions. That state law provision has not been challenged, but it's something that, just to consider, because housing providers often ask people to execute lease agreements or addendums to lease agreements that provide restrictions on the use of a service animal or emotional support animal. On the other hand, sometimes it is useful to have an accommodation that's been granted in writing. I've certainly had tenants contact me after the management company responsible for their housing has changed, and then they run into all kinds of difficulties with their assistance animal being at the property because it's not documented in the tenant's file or in a lease or lease addendum that the dog has been approved as an accommodation at the property. So really, when you're faced with addendum issues or lease issues involving assistance animals, you really want to take a close look at specifically what they say. There are some addendums floating around, for example, that make vaccination requirements or licensing requirements part of the lease agreement, and that I would say is not permitted. I've seen some lease addendums that try to make it part of the lease, implement requirements on how often you change litter boxes and things like that, which is really regulating somebody's housekeeping habits. Again, not appropriate as a lease term. So you should push back about those sort of things. And that's something that DREDF is looking at currently, along with some other organizations. So if you do have those types of issues come up, feel free to reach out to me. A person can have more than one assistance animal. The key is that each animal has to be individually determined to meet the requirements for an assistance animal. So for example, someone might have an emotional support cat and then also have a large dog that provides them with stability when walking or with transferring from sitting to standing, things like that. Since the different animals are addressing different impairments of the person, they may both be permitted. But then when you're evaluating whether there's an undue burden or fundamental alteration on the housing provider, the cumulative impact of having multiple animals in the same household might be considered. In terms of handler responsibilities, a person with a disability is responsible for feeding, maintaining, providing veterinary care, and controlling their service animal. And they can do that on their own or with the assistance of friends, family members, volunteers, IHSS workers, what have you. They don't have to necessarily provide the care themselves. The key is that they can't transfer or shift responsibility for their animal to their housing provider. That would be a fundamental alteration. A housing provider can impose reasonable conditions on the presence of an assistance animal. For example, restrictions on waste disposal, an animal behavior that may constitute a nuisance, with the caveat that conditions must not interfere with the normal performance of the animal's duties. For example, a leash requirement on a property may interfere with the ability of a assistance animal to assist their handler, in which case the animal may be allowed off leash and under voice control, if that's possible. That type of situation, I would think, is really rare. But for example, if someone has a mental health disability and has flashbacks or panic attacks that make it difficult for them to enter dark rooms, and their service dog enters rooms before them to flick on lights with its nose, a housing provider can't tell somebody you can't let your dog off leash to go into the laundry room to turn on the light, because that would be interfering with the ability of the dog to perform the tasks that it's supposed to perform. Another example is a no noise requirement. Would probably interfere with a dog's job of alerting people who are blind to danger or to someone at the door. But if the dog is barking all day and all night, and when the individual is not even home, that may violate lease provisions relating to the quiet enjoyment and may be considered a nuisance. It's always a case-by-case analysis. A little bit about what the so-called interactive process. Under both the Fair Housing Act and the Fair Employment and Housing Act, housing providers cannot just deny an accommodation request for an assistance animal without having some sort of interactive process with the tenant or prospective tenant who's requesting the accommodation. Under the Fair Housing Act, before denying a reasonable accommodation request due to lack of information confirming an individual's disability or their need for an assistance animal, housing providers are encouraged to engage in a good faith dialogue. And this is what they call the interactive process. Under the Fair Employment and Housing Act, the interactive process is actually required thanks to regulations that were put into place in January of 2020. A couple of cases under federal law, so this applies to the Federal Fair Housing Act, that are relevant to folks working in California. The first is a Ninth Circuit case called Howard versus HMK Holdings. That case held that there was no standalone liability for the failure to engage in an interactive process under the Federal Fair Housing Act. And what that means is a tenant can't sue a landlord solely for failing to engage in an interactive process by itself. Compare Rodriguez v. Morgan, which is a Central District case where the courts held, consistent with some other cases in California, that the failure to engage in an interactive process can still be considered in determining whether a housing provider failed to provide an accommodation. So again, not on its own a claim, but the failure to engage in an interactive process is a factor when you're evaluating whether or not a housing provider failed to reasonably accommodate. And then the joint statement of HUD and the Department of Justice use the term should. So it's encouraged to just talk things out. Again, under the California law, the interactive process is required. A housing provider must engage with the requestor or their representative. Purpose is to exchange information, to identify, evaluate, and implement accommodations. Providers can't insist on specific types of evidence. A medical exam cannot be required. You cannot require somebody to turn over sensitive medical records or to identify their specific diagnosis. If a housing provider believes that a request cannot be granted, the provider must engage in the interactive process to determine if an alternative is feasible. So under state law, there is an individual claim for not engaging in an interactive process. A service animal can only be excluded if allowing the animal would impose an undue financial or administrative burden or would fundamentally alter the nature of the housing programs. If the specific animal the assistance dog may also be excluded if it poses a direct threat to the health and safety of others that can't be reduced or eliminated by another type of accommodation, or if the animal would cause substantial physical damage to property. When you're looking at undue financial or administrative burden, some of the factors are cost, benefit to the tenant, financial resources of the provider, and the availability of equally effective, less expensive alternatives. Some cost or financial burdens on providers is to be expected. And then with fundamental alteration, the question is, does the request alter the essential nature of the operations? These types of defenses don't usually come up in service animal or assistance animal cases. The one that does come up quite a bit is direct threat. An assistance animal need not be allowed if the animal constitutes a direct threat to the health or safety of others, and that means a significant risk of bodily harm, or would cause substantial physical damage to the property of others. Factors considered include the nature, duration, and severity of the risk and the likelihood that the threat will occur, and whether there are any accommodations that will mitigate or eliminate the threat. And it has to be a case-by-case evaluation, an individualized assessment, not about the breed of dog generally or about dogs generally, but about the specific dog or cat or whatever animal in particular. That's what this slide says. Individualized assessment. The assessment must rely on objective evidence about the specific animal's conduct, and a determination of direct threat cannot be made on evidence that's so old it's not credible or on mere speculation or fear. Assistance animals are allowed anywhere that tenants are allowed, unless it would create an undue burden or fundamentally alter the provider's services to provide access. And again, that would be really rare. A slide on California Bill AB 468, which some people might have heard of. It's a bill that was enacted in 2021. It requires a business selling emotional support dogs and or vests, tags, or certifications to notify the buyer that an ESA, emotional support dog, is not specifically trained to be a service dog and is not entitled to the rights and privileges accorded to law to service dogs. And it also places conditions on healthcare practitioners providing documentation relating to an individual's need for an emotional support dog. There's a site there. So how does AB 468 impact fair housing rights? It doesn't. So when AB 468 was enacted, a lot of people had questions and concerns about how this would impact fair housing rights. Really easy question or answer. It doesn't affect fair housing rights at all. It's written into the code that it doesn't. So just keep that in mind when doing your advocacy. And there is a, I added a link down here to a DFEH publication, now the Civil Rights Department, on emotional support animals and fair housing law. They also had a question and answer regarding AB 468. Now I wanted to do, because we have a couple of minutes, a couple of hypotheticals. Feel free to jump in the chat with your answers. The first is for tenant Blanca. Blanca applies to rent a vacant apartment and notifies landlord that she will be bringing an emotional support animal. Landlord wants proof that Blanca's dog is a real emotional support animal. Landlord tells Blanca that in order to process her application and approve her request, he needs her to provide medical records with her diagnosis, proof that the dog is a certified emotional support animal, and licensing and vaccination records for the animal. Are the landlord's requests legal? Okay, folks are weighing in. Very good. Everybody is saying no. No, the answer is no. The landlord's not entitled to medical records or a specific diagnosis. There's no requirement that an animal be certified. And although assistance dogs must be licensed according to city or county rules and vaccinated like any other animal, it is not for a landlord to track or enforce these requirements. They are not part of the landlord-tenant relationship. Second hypothetical, Bernie. Bernie is deaf. Bernie applies for and is offered an apartment to rent. Bernie informs landlord that he has 2 assistance dogs the day before he moves in. Landlord tells Bernie that the apartment building is a no dogs building, but agrees to allow one of the assistance dogs as an accommodation. Landlord presents Bernie with a lease addendum that says assistance dogs are permitted in all public areas of the building except the laundry room because it's quite small and other tenants don't want dog hair getting on their clean clothes. Have Bernie's rights been violated? And if so, how? Only one answer? Okay, this is kind of a trick question. The answer is maybe and yes. It's really unclear at this point whether Bernie has a basis for 2 support animals or assistance animals. So more information is needed. This is a situation where the interactive process would come into play. On the second issue of the addendum, although addendums are not prohibited, assistance animals should be allowed in all public areas, including the laundry rooms. The desire not to get dog hair on clothes is not cause for excluding a support animal. Okay, third hypothetical. This one is for Beth. Beth has reoccurring depression. Her treating physician recommended that she get an emotional support animal. Beth goes to the local shelter and adopts a kitten. Approximately 2 weeks after adopting the kitten, Beth moves into a new apartment. Although the application asks whether applicants have any pets, Beth does not disclose the kitten on her rental application. After a few months, Beth's landlord discovers that Beth has a kitten and gives her a 3-day notice to get rid of it. Beth emails the landlord that the kitten is an emotional support animal. Landlord does not respond to Beth's email and notices her for eviction based on fraud. In other words, that she failed to disclose the kitten on her rental application. Are the landlord's actions discriminatory? How would you approach this situation? Both messed up. I like Lois's answer. Thank you. Okay, the answer is the landlord's actions are discriminatory. Beth is entitled to an emotional support animal. And yes, Alexandra is right. Request for accommodation can be made at any time, even after a notice to quit or a notice of eviction. And I provide some sites there to the California Code of Regulations and also to the HUD DOJ joint statement, which provides that the Fair Housing Act does not require that a reasonable accommodation request be made in a particular manner or at a particular time. Additionally, right, Joseph's right. Emotional support animals are not pets. The failure to disclose in response to a pet question on a housing application is not fraud. Although a housing applicant may prefer that an applicant make reasonable accommodation request on their rental application, you cannot deny a request for that reason. And there's a good reason for not asking people to disclose emotional support animals on their application or service animals, because it tells the landlord that the person applying for the housing has a disability, and it allows people who are inclined to discriminate to go ahead and screen you out at the application stage without being able to prove that they did so. So although I don't ordinarily advise people to be disingenuous, there's balancing of interests here. I'm right at 12:30. I'm going to go ahead and pass it on to my co-presenter and stop sharing my screen. If there's time at the end to answer a couple of questions, I will do so. Also, feel free to put questions in the chat. And while Amalia is doing her presentation, I can address the questions that have been posted. Thank you very much.
Hi, everyone. Thank you so much, Michelle. That was fantastic. My name is Amalia Romero, and I will try to share my screen. If you'll bear with me a moment. Okay. Okay, so my portion of today's presentation, I believe you can see my screen now. If
Yes, we can see it fine.
Thank you.
Yeah.
So I'll be presenting on source of income protections. I am a senior attorney with the Legal Aid Society of San Diego with our fair housing team, and we've done a lot in this area. So I'm excited to share a bit. The source of income protections in California come from the government code and originally SB 329. Have the citation here. It's Gov Code 12955, specifically subsection P is primarily where it comes from. And that became effective in January of 2020, a few years ago. I also will just highlight here that in addition to the Fair Employment and Housing Act, there's an argument that source of income is covered also by the UNRRA Act. And of course, we have California regulations that apply here. We've also analyzed and brought at least an administrative complaint based on and in negotiations with landlords before, arguments that this also could be a federal Fair Housing Act claim based on a disparate impact because folks on rental assistance, and in particular throughout this presentation I'll be referring to Section 8, are disproportionately people of color, people with disabilities, and also families with minor children. So just wanted to highlight that as well. And also, of course, there may be local laws that could be applicable in your area. We have one down in San Diego, so just keep that in mind as well. And I apologize, I have a bit of a sore throat today, so excuse me if I have to pause anytime during this presentation. So what the state law back in 2020 did was expand the definition of source of income, protected source of income, to include housing assistance, rental assistance programs. And it's a pretty broad definition. I'll go over it in a moment, but it's going to cover both government and nonprofit assistance programs. And it expands what the prior definition of source of income was. So quote unquote source of income has already been a protected class for a long time now under the California law. And it was originally meant to address situations where, maybe a person has income from disability or unemployment or child support or something other than employment income. And housing providers who maybe prefer only renting to people who have income from a job would discriminate on that basis. And so that was the original intent for this source of income protection. And the 2020 expansion meant to include rental assistance, third-party payments. So that definition is lawful verifiable income paid directly to a tenant or to a representative of a tenant. And that was the old definition. And now with the expanded definition, it also includes income paid to a housing owner or landlord on behalf of that tenant. So it's going to cover those rental assistance programs, including nonprofit third parties, but the statute explicitly includes rental assistance from federal, state, or local housing programs, and also explicitly mentions Section 8 housing choice vouchers as protected. I am obviously down in the San Diego, so I won't dwell on this part too much, but we do have our own local ordinance that was passed prior to the state law expansion. And what I will just highlight is that it's important to be aware in your jurisdiction if there's a local ordinance that might be at play in addition, or important to be aware how it might affect source of income claims in your area. So just emphasizing again what protected rental assistance is. A lot of people, when we're thinking about these source of incomes laws, immediately think about Section 8, which, is the primary thing that people talk about when we're talking about these laws. It is a longstanding, very large program across the nation for low-income households to be able to afford their rent. But like I mentioned earlier, this law is not just about Section 8. It includes other programs, and there are so many out there, especially since the pandemic. So, there's programs similar to Section 8 where it's kind of a monthly subsidy, but it could also be a security deposit assistance. It could be a one-time monthly, 1 month assistance, a couple months, rapid rehousing for 6 months or 12 months. It can look like a lot of different things. So it's important to be aware of that, especially as a housing provider, that it's not just Section 8. If you're presented with some other third party type of assistance, this law is going to be at play. I just want to emphasize or give some background on the need for this type of law. As we all know, the rental market's pretty tight, especially in recent years, and we need landlords to provide housing options for people, including people with low incomes. And previously, landlords could automatically decline to even consider an applicant who received rental assistance. That automatic no ended up really, really severely limiting the options for housing that are available to low-income households who had rental assistance and maybe otherwise qualified to rent that unit, and were blocked from even getting the chance. So there was a website called Go Section 8. It's renamed now, I think, affordablehousing.com. That, it was kind of the starting point for people with Section 8 to go. It's an advertising website, because housing providers that would post there were already pre-inclined to accept Section 8, whereas, going out into the private market would basically, you'd be anticipating no Section 8, those automatic no's left and right. So that need ended up really prompting a shift in trying to address it and trying to increase the housing opportunities available for people, increase choice if folks who can afford the rents because they have these assistance, to be able to move to other neighborhoods that maybe have more resources, better transportation, better schools for their children, better job opportunities, giving people the choice. Because something like a Section 8 voucher, you can take with you out into the private market anywhere in theory you want. And so actually making that opportunity a reality is part of the purpose of this. Also, we want to decrease the time needed for households that have rental assistance to actually find a unit and use that rental assistance. Before these laws, especially, we would see it taking a really long time, months at least, for households on Section 8 to find a landlord and actually use that voucher. For programs like Section 8, and I imagine most assistance programs, there's a time limit on, you get the voucher, and if you don't use it within a certain amount of time, you lose it. And that's really unfortunate. So wanting to decrease the time that people are in this limbo period. Also, we want to reduce the concentrations of poverty. At the very least, I haven't looked into it as much recently, but in the time leading up to the local ordinance in San Diego, we would see that Section 8 voucher holders, there would still be a concentration in low-income neighborhoods where Section 8 vouchers were being used. So even though, like I said, those vouchers are meant to be used out in the private market wherever you want, in reality, with so much discrimination based on Section 8, people would end up getting funneled and concentrated into those low-income neighborhoods. So expanding those opportunities will expand, the options to go to other neighborhoods as well, if people want. And then, of course, preventing homelessness. Obviously, these laws are not the end all be all. It's a very complicated issue, but there are a lot of homeless assistance programs out there that, with fewer discrimination against that type of assistance, it will help. And this is a bit of an outdated map, I will note, but just I like to have the visual because as you can see, or I will note that California on this map is not green yet. There's across the country prior to California and passing the source of income protection, there were other states, other counties throughout the country that already passed similar protections like this. So this highlighting this is not a novel idea. You might note that Texas is a different color. It's red because they are the only ones that actually did the opposite in response to a local ordinance passing for source of income protection. The state legislature then responded saying, localities, you cannot pass this type of source of income law. So they did the opposite, but as you can see, the general, everywhere else, the momentum is towards having this type of protection. And to get into a little bit of the substance on prohibited activity, the city ordinance is lays it out pretty explicitly, but this is applicable for the state law as well. So it's going to be illegal to refuse to enter into or renew an agreement for tenancy based on a person's source of income. So at that application stage, or if there's someone in the middle of a tenancy and they get a Section 8 voucher, they come off the wait list, get a voucher, want to use it where they're living, landlord refuses to renew that agreement because of it, that'll be illegal. Also used to see a lot the non-renewal notices with Section 8 voucher holder tenancies. That's also going to be illegal when it's because of their source of income. And then interrupting or terminating the tenancy because of source of income. We used to see, like I said, a lot of the termination notices saying we're no longer participating in Section 8. Those are illegal now. Falsely representing that a unit is not available for tenancy. It's pulling from old, the Fair Housing Act, where if a housing provider says, oh, that unit's no longer available, actually, upon hearing that a person has Section 8 or some other form of rental assistance, but if that unit actually is available, and they just said that because they don't want to rent to that person, going to be illegal. Requiring any clause, condition, or restriction on the terms of the tenancy because of source of income. So kind of along the lines of what Michelle was talking about for putting a condition on a reasonable accommodation, putting a condition on a tenancy that has, maybe a Section 8 voucher. I'm going to charge you a higher security deposit. I'm going to charge you a higher monthly rent. You don't get a parking spot while everybody else does. Things like that are going to be illegal as well. And restricting, and along similar lines, restricting a tenant's access to facilities or services on the property, or refusing repairs or improvements. We see that as well. Section 8 voucher tenants have to be on this floor or this part of the property. You don't have access to the community pool or other facilities. And then, we see ignoring or delaying responses to requests for repairs, that kind of stigma attached to these voucher holder households, and the, resulting to differential treatment, that those things are going to be illegal. Also prohibited is discriminatory statements. So it's unlawful to make, print, publish, advertise, or disseminate in any way a notice, statement, or advertisement that indicates a preference based on a person's source of income. So usually when we think about statements, we think about advertisements, discriminatory advertisements, but just highlighting that it can be any written statement, verbal statement, and it doesn't have to be this blatant no Section 8 like we used to and still sometimes see these advertisements. It can be a bit more nuanced if it indicates any kind of preference against rental assistance, then that's going to be problematic. We have seen things like we're not registered or we're not pre-approved for Section 8. It's not really how the program works. And maybe the landlord is saying, I'm not saying no automatically, but I'm just letting you know that it might be a problem at this unit. It's going to be indicating preference. It's going to be discouraging someone with a voucher from renting there or trying to apply there. So that definition of discriminatory statement is pretty broad. Also prohibited when it comes to financial or income standards. So sometimes a housing provider is going to require that a person make 2.5, 3 times the rent to be eligible to rent a place. And so that comes into play. Actually, it was already a provision in the California law prior to the 2020 expansion, that when you're dealing with a subsidy like Section 8, where the tenant's only responsible for paying for a portion of the rent, then that 3 times comparison has to be done against the tenant's portion of the rent, not the entire contract rent. And it makes sense when, again, in reality, that tenant's not responsible for the entire contract rent. It doesn't make sense to make them prove 3 times the full contract rent when the government's going to be paying everything other than the tenant's portion. And then because programs like Section 8 are for low-income households, if a person's making actually 3 times the contract rent, they're probably not qualified for the Section 8 program. And so in effect, that kind of application of financial or income standard is going to exclude almost every Section 8 voucher holder. So we see that violation happening a lot even now, and even amongst larger property management companies where maybe leasing agents aren't trained on this. So really important to be aware of it. And just a quick example, I wish I had a slide so it's a little easier to follow, but maybe a person who has disability income makes about $1,000 a month. Maybe their portion of the rent is going to be around $300. If the rent on a unit is $1,500, they're not going to be required to make 3 times the 1,500. It's just going to be 3 times the 300. So just kind of an example. And I will note that there are fact sheets. The Civil Rights Department has put out a couple of fact sheets, and at least one of them has an example of this. So that can be helpful to educate yourself, educate others on that. And as far as common violations go, I did want to pause and emphasize, like I said, this, the income standard is a common one we see. The discriminatory statements, like I mentioned, even if it's not so explicit of no Section 8, the comments about not being registered or, oh, I don't know much about the program, things like that, just designed to discourage folks from applying. I also see refusal to complete documentation, where a housing provider might say, oh, I'm not refusing Section 8, I just don't want to do the documents, I don't want to provide what they're asking for. That's going to be problematic under the law. Also mentioned charging additional deposits, fees, or rent. We see that. Even before this law, we would see sometimes purposefully failing a housing inspection, a housing quality standards inspection. So part of Section 8, at least, is that the unit has to pass kind of minimum housing quality standards in order for Section 8 to approve the unit. And so purposefully failing when, maybe it's a very simple fix that is needed, but landlord just doesn't do it because they don't want the unit to be approved by Section 8. That's going to be problematic under this law. And next, just to note the exception, which is the same for fair housing laws in California. there's going to be an exception for an owner occupied unit. So if the homeowner lives in their home, single family dwelling, and they rent out a room or a portion of that home to a renter, as long as it's no more than one person, that landlord is going to be exempt from having to comply with this law, except for the fact that they also cannot make discriminatory statements. So what happens if a housing provider fails to follow the law? One remedy is a lawsuit. We've filed a couple on behalf of clients, and you can seek, the tenants can seek monetary damages as well as non-monetary injunctive relief against the landlord. And the court has power to award punitive damages, attorney's fees, and costs as well. I'll note that our local ordinance, and again, just note to remember your local claims as well. If a court determines that there's been a violation, it's a mandatory 3 times the monthly rent that the unit was going for at the time of the violation. In addition to lawsuits, an administrative complaint is an option. California Civil Rights Department is the agency charged with investigating and enforcing fair housing laws in California. It's an option to make an administrative complaint. As I mentioned earlier, there may be an argument for disparate impact. So if you want to try to bring that federal claim to HUD, which is the federal agency that takes in fair housing violation investigations, can try that way as well. And then, of course, aside from these more formal enforcement efforts, at least our organization does a lot of trying to negotiate things more informally with housing providers all the time. And again, just another note to remember your state versus local requirements. I will just note, like, for example, our local ordinance, we have only a 1-year statute of limitations to bring a lawsuit, whereas, you know, the state law is going to have that 2-year time frame. So just another plug to remember your differences. And just to highlight some of the perceived issues versus the actual process, in particular for Section 8, but maybe applicable for other programs as well. There's a lot of stigma attached to Section 8, and some of it, I think, is based on a misunderstanding of the program. And so processing time is a perceived issue. Yes, there's going to be some additional documentation that's required. Yes, you've got to work with the housing authority to get things approved. But generally, it's not the same as it was decades ago. And things, you know, with the electronic transmissions and things like that, things can be streamlined, and it's works even more efficiently if the housing provider has taken the steps to learn about the program and they know what they have to provide. They're familiar with the forms. It's going to be a faster process that way. Perceived issue of security deposit, inability to pay. There are a lot of deposit programs out there. One of our local housing authorities has a program for that specifically. So again, don't discount an applicant just because there's, you know, a question whether they have the deposit money in hand right then. A perceived issue of frequent inspections. The government's going to be in the unit all the time. Not really. There's that initial inspection prior to leasing up with a tenant, and then depending on your housing authority, it's either every year or every 2 years for a housing quality standards inspection. Idea of being subject to maximum rents. There are limits to what the housing authority is going to approve. It's going to depend on the payment standards in your area. Generally, the housing authorities try to keep up even in this, you know, kind of ridiculous rental market where rents are really expensive. But also I will note that the payment standards that are put out by the housing authorities aren't necessarily the absolute maximum that the Section 8 will approve. There's a lot of factors that go into it, and also people may be entitled to a reasonable accommodation. So definitely word of caution of refusing an applicant just because your rent maybe is a little bit higher than the payment standard. Perceived issue of tenants' inability to pay. Some housing authorities might have some protection against financial losses. One of ours has a program like that where a housing provider can kind of make a claim on the back end of a tenancy if there's a balance. But again, also for a program like Section 8, a tenant's, paying a portion of the rent, but the rest, the government portion, is guaranteed every month, right? And then a perceived issue of property damage, again, that stigma attached to this program. In reality, Section 8 tenants are incentivized much more than a regular tenant to be a good renter, because if they aren't, they risk losing that rental assistance. So just kind of want to give a little bit more information on the program. And I kind of already highlighted some of the benefits of the program: consistent, timely rent, some free listing services available, inspections every couple of years or every year, to make sure the unit's doing in good shape. And a lot of housing authorities, especially in response to this 2020 law, have made efforts to try to be more available to housing providers, answer questions, and help out. And then generally what we are telling tenants, educate uninformed landlords. Sometimes there might be a smaller mom and pop landlord that just doesn't know and aren't necessarily malicious. And when they learn about the law, they're going to follow it. And so, like I mentioned earlier, there's a lot of fact sheets out there that can help with that. Keeping communications in writing is always helpful. Applying anyways, if that's possible. I get that it can be expensive, but if a person's, confident that they're probably going to otherwise qualify, and if they get denied for, seemingly pretextual reason, that may just set you up better for a claim. And then emphasizing reasonable accommodations. Michelle just did a great presentation on one type of reasonable accommodation, but we sometimes see and assist clients, like if they got denied for a credit history issue, if there was a disability related reason because of that, and now they have a Section 8 voucher, so they're going to be more reliable to pay the rent, there might be a reasonable accommodation available to get that tenancy approved. So I am just about at time, so I'll stop. And if there are any questions, shoot. Sorry, I went just almost to the end.
This is Michelle. There's a couple of questions in the Q&A that I don't know the answer to. There's 3. I don't know.
Am I still sharing my screen? I stop share. Okay, sorry. Okay, well now I can see the questions. Okay, so are landlords required to complete documents necessary for tenants who are applying for county rental assistance? A lot of tenants' applications are not processed because landlords ignore requests to complete documents. Then the tenants cannot pay their rent and get evicted. Yeah, I think that that's probably going to be really problematic under these source of income protections. Like I mentioned, there's lots of different types of rental assistance out there. Something like a county program is pretty clearly going to be under there. So I think that could potentially be a fair housing violation. Of course, everything is going to be case by case, and I would encourage folks to be referred to their local fair housing organization. Were there other questions that I am not seeing? Oh, do the tenant protection laws that govern Section 8 housing equally protect affordable housing units? Tenant protection laws that govern Section 8. I'm not sure I fully understand this question. Protect affordable housing units. If I'm understanding the question correctly, there, like, for example, if there's a affordable housing property, like if there's a HUD building or something, the state source of income anti-discrimination laws may apply, but there might be like a federal restriction that says, this building, the people aren't going to be eligible if they have a Section 8 voucher. That might take, priority over the state law, but again, that's going to be dependent on the building and their, regulatory agreement. And can a landlord require a minimum credit score for a Section 8 voucher tenant? I think I kind of addressed that. Yes, housing providers can have their usual criteria and apply it as long as it's being applied and they're otherwise lawful and non-discriminatory, that, you know, you can have that minimum credit score requirement. Again, though, if you get a reasonable accommodation request related to that, you've at least got to consider it and engage in the interactive process.
Okay, well, thank you, Michelle and Amalia. Is there a way that participants can reach out to you directly for any unanswered questions?
This is Michelle. I'll put my email in the chat.
Same.
Okay, thank you. And thank you everyone for participating. If you could please take a minute to fill out the survey that I posted on the chat, that would be great. And we will see you next week.
Thank you, everyone. Have a great weekend.
Thank you.